Hello and welcome to this episode, the first episode on corporate governance. In this episode, we're going to speak about board composition, the nature of the board composition, and some important concepts relating to governance. To discuss these issues, we have the privilege of the company of Mr. Ashok Gupta from the Aditya Birla Group and Mr. Narayan Shankar from the Mahindra Group. We're going to discuss a range of issues around governance and the composition of boards in the governance of corporate world in India. In the Companies Act 2013, we've seen some serious inroads being made in terms of statutory definitions and legislated concepts in the area of corporate governance. So can we start by talking a bit about what the Act does in terms of composition of the board, and more importantly, sections like 166, where the duties of a director have actually been spelt out in legislated provisions rather than leaving it to common law principles of fiduciary nature. So if I can ask you to first give an overview of board composition, and then Ashok to elaborate a bit on how duties have been cast by statute. We could kick off on that basis.
Sure. Today, in terms of composition of the board, there are three new elements which have come in. One, public companies would require to have a resident director. Companies also, certain prescribed class of companies would require a woman director, as well as then the third class is an independent director. All the term independent director again is defined.
Yeah, we'll come to the independent director by itself as a concept, but I thought before we go there,
Sure.
If you could look at duties of directors as a whole, regardless of character of what type of director it is, can you throw some light on what are the duties cast on directors and how these provisions will work?
Yeah. So under the 1956 Act, the director's duties was under common law under the heading fiduciary duties. Now the contours of fiduciary duties were very broad. I mean, it entirely dependent upon the discretion of the person who's exercising it and the person who is judging it. Obviously, it didn't work because there were variability in terms of casting what duties are under fiduciary duties, and therefore, for the first time, perhaps in the world, the duties have been now legislated, as you rightly put it. And to my mind, all the duties which are mentioned, I can touch upon various duties which are mentioned, are typical fiduciary duties a director is expected to discharge while acting as a director of the company. So some of the duties which are already mentioned here and legislated are in the nature of to act impartially, act independently, not to have a conflict of interest, not to have undue gain for himself or for his relatives, and exercise due care, skill and diligence, and act for the benefit of not only shareholders, employees, community, and protection of environment.
Right.
So for instance, in the beginning, fiduciary duty is a very broad term. I would guess as a responsible director, even in 1956, he would look not only at shareholders' duty, but also would like community, employees. Ultimately, you need to earn license to operate in a corporate world, and you can't have a license unless you take care of the stakeholders.
Right. So it's beyond shareholders; it's even stakeholders.
Absolutely.
So this could now mean that if you owe a duty to a creditor, for example, as a director, you got to be thinking about whether your actions would impact someone other than the shareholder who's appointed you, including creditors, including consumers, government agencies, etc.
Yeah, they're important organs for the business in any case.
Right.
So, for instance, if even we take a call as a director that something is not going to work for the benefit of the creditor in the long term, we are going to impact our business interests because nobody will come forward and give credit to the company and business. So, therefore, you need to really balance conflict, which apparently looking very conflicting. They are not very conflicting duties, but one has to really apply their mind in saying that action of the company are not influenced by a single factor, but has to take care of various constituency and then take action, which in my view is good for the long-term business of the company.
Right. So 166 therefore would be what lawyers would call a principle-based law, where the principle that you shall act with due skill, care and diligence, the principle that you shall take into account the interests of all persons impacted by our decisions in the manner in which you take decisions. So how do you see this as a material departure in terms of codification, but codification with a wide scope of what the duty should be?
Duties of directors have always been. It was more fiduciary responsibility, which has evolved over a period of time through case laws and codified in that manner. But for the first time, the section not only talks of the duty of care, skill, what he has to do, but it goes into micromanagement of even mentioning that he will uphold ethical standards, the director will act objectively, he will refrain from any action which will lead to loss, he will devote sufficient time and attention to the professional obligation. So besides the generic fiduciary responsibility, the section and the Companies Act today goes into even nitty-gritties and micro as to what really is expected of a director.
Right. Therefore, Ashok, for a court of law which is enforcing the act, now there is a barometer that's available in actual language written in the act, rather than leave it open to a court to decide whether its fiduciary capacity has been well occupied or not. Would that be a fair statement?
It is, because they're part of the law.
Right.
And court is expected to look at the law and interpret it.
Right.
And earlier, when it was fiduciary, it is for the court to decide what fiduciary means in a given context.
Right.
Because it is a context-driven definition in that sense. So, in a manner of speaking, it might lead to issues. Anybody and everybody can go to the court of law who would say, okay, these are the duties defined and they have not discharged it. And the court then have to see the context. I can understand that concept now bringing in and creating more difficult life for the company and its directors. But I think it will settle down over a period of time, because there are two reasons to my mind why these are defined now. One is that naturally the fiduciary duty did not work. If it had worked well, there was no need for anybody to define it here. And secondly, it facilitates the task of a director, that you don't even look at shareholders' point of view or manager's point of view or management's point of view. Look at everybody's aspect. Ideally speaking, this could have been done in a very different fashion,
right,
by having a guidance notes rather than incorporating in the legislation. But now it is a fact. And so long as the courts are taking a liberal view rather than a stricter view, I think this should work.
Right. And unlike fiscal statute, when you
Yes.
interpret a regulatory provision like this, you will need to purposively construe it in the light of the legislative intent.
To a certain extent, it would also be onerous on the director to balance conflicting interest.
Right.
A shareholder and a taxpayer, taxman, both
Right.
would be a stakeholder in the company.
Right.
How would he balance that interest? Community at large, polluting industries, environment at large. So how do you really balance such conflicting interests? It would really be a challenge.
Right. It will be a question of fact in each case.
In case.
Like, are you minimizing tax incidents for the
Absolutely.
benefit of your shareholders, but within the compliance norms under tax law?
Yeah.
So each director, I would sense, is then put to the task of asking this question to himself when he endorses or supports a decision recommended by the management. Should we move on then to the independent directors? I wanted to pause and get into the wider picture before going there. Can we talk a bit about who is an independent director and what does the Act do in terms of what role does it envisage for independent directors?
Today, 149 defines an independent director. For listed companies, clause 49 today already has a standard definition.
Under the listing agreement.
But now for other class of companies, public companies, you will have certain class of companies having turnover, paid up capital of 100 crores, a turnover of 300 crores, or having outstanding loans to get into independent directors, which will be 1/3 of the board strength. And the key difference with they are making a mention for the purpose of director, if he has pecuniary relationship with the company its subsidiaries, holding, associates, he will not be deemed to be independent directors. Here the word material has been dropped, which is there in clause 49 of the listing agreement. The second interesting and differentiating thing is the board has been cast with the responsibility of opining that the concerned director is a person of integrity and he possesses the relative skills, experience, expertise to enable him to do this job effectively. If you recollect, in 2004, when SEBI had amended its act, it went from the onus of the board to a self-certification of the directors, where directors self-certified to the board that they are not in any conflicting situation or they are not in a situation which will hamper their independence. So today you are again going back into a regime where the board has to appoint. It will be a combination of self-certification and the board appointing that a person indeed is an independent director. I thought these two changes have material, and of course all public companies beyond a particular threshold would require. And the third aspect is private companies requiring independent directors through a circuitous route of CSR provision. As you're aware, CSR is applicable both to public and private companies. And there is a duty cast on the company to have a CSR committee which will have a CSR policy and implemented it. And one of the requirement is to have an independent director in the CSR committee. So if you have a private company, and even if you have just a profit of 5 crores, if you just have 2 directors, today you'll have to appoint a third independent director because CSR applies both to public and private companies.
Right. Ashok, would you have a comment on that? That why not then say that all companies shall have independent directors? Or would it be that in a private company you may have a director who's independent but not necessarily in conformity with section 149?
Yeah, the only one is why not all companies should have independent directors. To answer that question first is I think there are practical compulsions. Number one, capacity of private companies to have and capacities and mindset of independent private companies to have a person not related to the family in a manner of speaking, to be on the board and engaging them. I mean, this is only a perception. I'm sure they're doing everything fine and they stand to gain if they have independent directors. But we are at infancy of governance mechanism, and therefore we need to deal in phases. So first phase is that it should apply to all companies of significant sizes. Listed company it was applicable. And secondly, once the law settles down and there is a general experience that this is going to benefit the company at large, I think private companies on their own would have independent directors. So the law is not mandating. I think they are taking a very gradual approach, which is good. On the CSR front, of course, the private company, the whole idea of CSR and objective is very different. Objective is that all companies who are making money or of a particular turnover must invest back in the societies. And I keep on saying there's a license to operate. So whether it's a public company or a private company, you need to have a license to operate in a community. Now, to oversee whether CSR spend is going to the right direction or not, they introduce the concept of independent director for those companies also. But rules are still being debated, as you know, and final outcome perhaps may avoid this anomaly. That if the legislature has decided not to have independent director for private companies, why would they have it for CSR? So I would not pass any judgment at this point in time.
But we are back to the independent directors and their role. Can you elaborate a bit on what does the Act expect an independent director to do, and how does the section 149 use this office of an independent director in furthering the objective of good governance?
Yeah. So the concept of independent directors, as like fiduciary duty, can be, without definition, can be interpreted in any way. If you're not related to me, you're independent. So to that extent, people will say, okay, he's not related to me, he's an independent director. But that's not what the intention was. Intention is, and it is a governance, and if you consider very positively, and I do, that it is going to help the business grow. So a director who is not related in any manner, pecuniary or otherwise,
Right.
and has the rich experience, integrity will bring number of positives on the table for the governance. Number one, he will give a different perspective in which we are operating. Macroeconomic situation, the industry, cross-industry benchmarking that happen. Sometimes we take a very inward view of the industry. But today's industries are breaking barriers. For instance, mobile industry going for banking. So is mobile industry belonging to banking or banking industry belonging to mobile? You need to really start challenging it. And a person who has a different experience and expertise will bring that on table. By his own attribute, because ultimately these are the value system, and we believe that we all have it. That we are person of integrity, we are honest, we are duty to care to the environment. Now it is ingrained in it, maybe to re-emphasize the fact that you need to have a person of integrity coming onto the board,
right,
who have the special skill and can add to the value of the company and its shareholders and stakeholders.
right.
And it will uphold the governance mechanism. All said and done, if you are doing on your own as an entrepreneur, there are somewhere down the line, you will break or breach.
Right. Can I actually interrupt and ask a question? When you say independence, it's independence from what? From the promoter or independence from the management, or both?
It is actually independent from promoter and management, both, as you mentioned, because one is, of course, the governance aspect of it. Second, also there should be a challenger. I mean, I'm not using in a negative sense, I'm a very positive
In any
sense.
system, you have a check and balance.
Exactly. You're a challenger. Management who's committed to a way of doing things. There is a challenger and showing a mirror, okay, can there be a different perspective? Look at this perspective. So you are in a position to take a decision which is very informed, considered decision. So that's how I read as independent director. So it has two parts. One is the business orientation, second is, of course, governance. But you're not totally dogmated by only achieving turnover and profits, regardless of its consequences.
Right.
And of course, independent director gets an objective view. While he challenges, at the same time, he is really not an adversary. He is actually supporting management by challenging strategy, performance, and whether in terms of risk management, and a whole lot of issues, where he is actually sitting from an outsider perspective of what you're really doing.
Right.
And showing a mirror
Right.
to the management, whether they're going in the right path.
See, I thought we could also move on to another important area for this episode, which is in the section relating to giving of loans to a director or persons in whom a director is interested. Section 185.
Yes.
Can we talk a bit about this concept? Because it's a new concept of not just saying an interested director, but saying that a director's interest in an entity, in which entity the director is deemed to be interested. So if you can elaborate a little bit about how this concept works.
First, broadly the provisions, it's an equivalent of section 295 of the Companies Act 1956, which is codified in 185. While the list of people are quite similar from the 295, whether in terms of the director, relative, firm, private companies, the one exemption which was carved out, which is not available under the new 2013 Act, is the exemption available for transactions or loan between a holding and subsidiary company. To add to this,
if you could just take a step back and actually dwell a bit on when is a director interested in an entity. What does the law say on that?
So as I said, besides these categories of a director, a relative, a private company through which he would be interested, the law also says that if you have another company, the board of directors, managing director or manager is accustomed to act in accordance with the directions of either the director of your company, then again it will fall under the mischief of a connected person to the director. And one view stems from the fact that a holding, specifically if you hold 100% of your subsidiary, it's presumed that the board of the subsidiary company may be acting. But of course, you have case laws both in the UK, not much in India, where they say this is really not a presumption that each board of the subsidiary is acting in or accustomed to act in accordance with the holding company. So it will be really a case-to-case basis.
Right. Ashok, can I bring you in on this? Would you say that the board of a subsidiary is accustomed to acting per the instructions of the holding company or the holding company's board? Or is there a room to say that because of 166, which we discussed earlier, each board is statutorily duty bound to do its own, and therefore there should be no presumption that a subsidiaries board would be accustomed to acting per the instructions of the holding company? Where would you draw the line on this issue?
I would draw a line on the latter what you said. There can't be any presumption that because if you draw that presumption, that will go to the very root of corporation itself. You go to an independent firm, its director, and they are supposed to. Then governance principle is
you lift the veil altogether.
You lift the veil
of every subsidiary.
Yeah. So you have to actually think through that each directors are responsible for its company and constituents.
Right.
And would not wonder whether it is a holding company or a subsidiary company. For him or her, the company is a company.
Right.
It doesn't matter whether
who the shareholder is, doesn't matter.
It doesn't matter at all. So therefore, they are supposed to act, and I would at least I wouldn't consider, and I haven't experienced many boards of subsidiary companies who have been accustomed to act, unless subsidiary company is more of an investment vehicle.
Right.
So that's a different issue altogether. But we're talking about subsidiary substantial operating company where the boards act quite independently, and I wouldn't hesitate to draw any such inference in such a matter that their board is acting in accordance with the instruction of the holding company directors.
Unless, of course, again it will be a factual situation.
Yeah.
If a majority of the two boards
Are common.
as common people,
Yes.
then it would be very difficult to say that when I wore one hat, I was not wearing the other hat.
It's challenging.
It's
Well,
challenging.
It is quite challenging, but many a times, in like intellectual property matters, it is quite regularly happening in holding company and subsidiary company. Holding company wanted to extract a value, subsidiary company, so it doesn't belong to you.
Right.
There has to be different values. So it's a very interesting dynamics. But human beings, say majority of directors are common, quite naturally, there will be some amount of impact.
Would it be fair to say that, leave aside how this will work, leave aside whether you can draw a presumption or not, would it be fair to say that such a provision will nudge companies towards not having such common directorships or minimizing such common directorships so that these issues don't actually arise for them? And in that sense, the law could be a tool to pushing companies to have independent boards and people who think for the company, as you say, rather than think for the shareholders who appointed them.
I'm not too sure. The reason is there are different considerations for appointment of directors. But one of the consideration is the knowledge of the cross sector and his own experience, which may be useful both for holding company and subsidiary company. So it is in the larger interest of the business to have him on board. Or just a case of a lawyer who is in the director, a senior designated lawyer who is in a holding company, and we believe that he upholds some certain value which should be extended even to a subsidiary company. And he would in his mind make a demarcation between holding and subsidiary company. Whether this provision is going to nudge, I'm not too sure. It might. It's too early to say that.
All right.
And equally wanted to supplement today, if you see clause 49, for example, it actually requires a holding company to have a review mechanism. And as part of the review mechanism, they say that at least one independent director from the holdco should be on the board of a subsidiary company. So actually, the listing agreement actually pushes you in that direction.
Right.
And here, one point of difference is a company can do business either as its own operations or investment through subsidiary. So you will have many companies which are operative and investment companies. So when you are doing investments, it's the company doing the investment and not the promoter or the director.
Right.
If the concept is the promoter or the director not getting undue gain, would be accepted. But the company's own investments, it was definitely protect its investment.
Right. Can we spend some time on two other elements you very briefly alluded to when we started? The need for a resident Indian or a person resident in India, if I may use that phrase, because 183 days is the test applied, to be on the board of every Indian company. Where is this coming from, and what does it seek to achieve?
One of the logic which at least I understand, if you have specifically in the private company, you will have subsidiaries of a foreign company or a multinational company where both the directors are in different places. And in case of prosecution, or in case where you want to really know where the directors are, it was becoming very difficult for the regulator to even serve a notice to the director
To
because
get
it
a
was not
man.
in India, to get a person,
Right.
human being, what you
Right.
call. Because today with the concept of woman director, I would really call a human being
Right.
to really to whom the notice could be served. That
Right.
was really, so in other countries, including Mauritius, every country has a concept of a resident director. So at least to that extent, you have one person responsible in India to whom the notices, etc., could also be served.
So there could be another perspective. So I'm not going on prosecution side. Another perspective is many a time you need to take a decision at the policy level.
Right.
So we all know that policy matters are decided by the directors, and if the director is not absent and there is an immediacy requirement, so that you need to take a policy decision. A director who is in India can take a policy matter and avoid a major crisis, a business crisis or anything. There could be other reasons also. It might actually create complication and tax purposes, for instance. When you decide the seat and brain, I mean, you would say that here is a person, catch hold of him. So that aside, but generally I think the person, if he's in India, he can engage with government bodies, all stakeholders, can speak on behalf of all the board of directors and carry forward the agenda of the company. I think this is a good development in that sense.
Right. What about the women directors bit? Is it a measure to increase representation, and are we going down the path of a reservation sort of approach? Where do you think this provision will take us?
Today, factually, or the threshold which they have laid is if you have a paid up share capital, the same threshold of an independent directors, and they are requiring corporates to have at least one woman director. Of course, all listed companies have been given a time period of 1 year, and unlisted companies have been given a time period of 3 years transition to move into that direction. And of course, very few countries really legislate on women directors, but I'm sure with this you'll have more women on board.
Right.
So I think the perspective here is, theoretically speaking, the male and female are 50-50, theoretically speaking, or expected to be, barring few states where things are happening. And it has also been internationally proven that diversity is really helpful. They bring different perspective completely. They would know the needs of that gender in that sense, or they have a different way of thinking, and it is both scientifically proven and contemporarily established. So therefore, and the whole idea of company, and we are operating in a society, we are not operating for male or female, we are operating for communities, whatever part of the business we are in. So I think it's a very, very good development to have.
Give a push to the idea.
Absolutely.
Right.
I mean, otherwise, I think company may or may not. The mere acceptance, if nothing else, the mere acceptance of the fact that women can stand up in the board with the board, that by itself is a good feeling, in my view.
So the boardroom is reflective of the society.
Absolutely.
And by impacting that, we may try to impact society.
Absolutely. We must accept this fact, and maybe they're better off than us. You never know.
Correct. Is there any other aspect that you'd like to talk about in this context of board composition and governance, and how it leads to an impact on the rest of the Act? If you could summarize your views on the Companies Act 2013 in this regard, on any issue which we've not touched upon so far.
All I can summarize, I think you ably covered all aspects on the management side. The issue of governance is not dependent upon the clause in the listing agreement or a provision under the Companies Act. It is a mindset problem.
Right.
Now, if you don't want to have it, with complying with all these provisions, still you don't have a governance.
You still not have governance.
It's as simple as that. So while the government is wishful thinking through legislative changes, is to bring that state of affair, and I hope it'll work. And I personally consider these provisions facilitating in that direction
Mm.
rather than establishing governance mechanism. It is facilitating. Eventually, it has to come from within. Number one. Number two is the governance is not only naam ke vaste. Governance is really in the interest of the business of the company. And people have to accept this fact. If one doesn't, in the company we don't accept this fact, actually we are damaging the long-term interest of the business. That's the second thing I would say. And the duties which are mentioned, even though on the face of it looks, can be onerous and can lead to some litigation. But I think these are general. We are supposed to imbibe those in any case. And the fact that it has been legislated now, that means it's our failure.
Right.
That's
As
how
a society.
As a society.
So this duty is owed to the company, and if this duty is defaulted on, it would be fair to say that a derivative suit can be filed by a shareholder seeking that the company be made good the damage by the failure of duty by the director.
Yes.
Right. Thank you very much. That's all we have time for on this episode. This is a primer with a very high level overview of some of the critical provisions. We encourage the viewers to pick the act and read the respective provisions and read the other provisions to which these provisions relate. That's all we have time for. Thank you very much. Thank you for being with us.